navigating the regulatory changes in Europe, adoption to MiCA and DORA,
Hello, dear all. My pleasure to meet you. I hope you are quite available for the new information related to the regulatory challenges and obstacles related with the upcoming MiCA and DORA regulation. My name is Anna Agu. I'm managing partner and co-founder at Lex Law Office, also the founder of CryptoFin Conference. And today we're going to talk about two different animals, MiCA and DORA regulation. And I would like to do this topic as simple as possible. But of course, regulation is always a little bit complicated to understand. So I will try to do my best. First of all, let's talk about the aim of the MiCA and DORA regulations. MiCA regulation was introduced in June 2024. June 2023 for the market participants to regulate the virtual assets issuance, and virtual asset service providers. And the DORA regulation, the aim of this regulation is to ensure the ICT risk management within the companies and ensure the standards within the European Union for the digital resilience operations for the financial institutions. DORA is applicable for 22 different financial institutions. MiCA is applicable especially for the virtual asset service providers and virtual asset issuers. Let's talk about the timing. So as I said, the MiCA was introduced in June 2023, and MiCA is coming into the force in two batches. The first batch was June 2024 for the Article 3 and Title 3 and Title 4, and for the other titles, MiCA is coming into the force by the end of 2024. So we need to be ready. This is upcoming regulation, which is changing a lot the virtual assets market in the European Union. For the DORA is coming into the force beginning of the January 2025, so 17th of January 2025. Companies should be compliant with the DORA requirements. So let's talk about the main benefits of the MiCA. First of all, it will be the one fundamental framework for the all market participants related with the crypto assets within the European Union. There will be no need to obtain for several different licenses within the European Union. Some companies who are authorized in one particular homeland and getting their license will be able to provide the services for other countries' citizens within the European Union by passporting. Also, there will be an opportunity to provide your services without the borders. We will have the unified register for the market participants, which will give an overview about the compliant market participants. It will be possible to review which kind of services company in particular can offer to the customers. And of course, exchange of the information, especially for the supervision purposes, it will be easier because we will have one standards for the market participants. And it should increase also the level of the market participants and help to develop the industry in general. And of course, the main idea of the MiCA regulation is the consumer protection, because we do have a lot of cases related with crypto scams and crypto frauds. So that's why this industry is under the scope of the regulation to protect the consumers as well. If we are talking about the issuance or offering of the virtual assets, it's really depending which type of virtual assets will be offered. If the company would like to offer the e-money token, they need to get the e-money license authorization. If the company would like to offer assets reference token, they need to get an authorization from the homeland. And if the company would like to offer other than assets reference token and e-money token, they need to have this white paper procedure. They need to draft the white paper, notificate and publish the white paper within the competent authorities of the homeland. And of course, they need to be in line with the Article 13 according to MiCA. As I said, we do have different classes according to MiCA, and determination of the virtual assets or crypto assets according to MiCA is one of the biggest challenges related to the MiCA regulation in general, because it's sometimes very difficult to fit the particular assets to the three different categories that are according to MiCA. As I said in the past, we do have assets reference token, we do have e-money token, and we having other than assets reference token and e-money token. And there is a lot of exemptions which kind of virtual assets will be not considered the virtual assets in scope of MiCA. For example, NFT, virtual assets which are offered for free, virtual assets that are issued only as a reward of the mining, etc., etc. If we are talking about the crypto service providers or CASPs according to the MiCA, we need to have a look on the legal term, who are the CASPs. So most of all, you need to pay attention to the legal term is related with the commercial activity on the regular basis to provide the specific list of the services mentioned in MiCA. So for example, if the company would like to provide the transfer services related with the virtual assets, exchange services, custody services, trading platform services, also portfolio management, placing of the orders, reception of the orders related with the crypto assets, and also, for example, consultancy services related with the virtual assets, they will be a subject of the MiCA regulation. Licensing or authorization. There is a lot of questions and doubts regarding the licensing process and regimes within the European Union, and different home states can choose between the transition periods that they will apply for the market participants who are already regulated in their particular countries. So the transition period by the countries is different. But in general, companies need to submit the very comprehensive application to the governmental authorities. The answer regarding the application, the initial answer will be done within 25 days, and after the final submission of the application within 4 months, companies will get the final answer by the regulator if they can provide the services according to the MiCA license. And in terms of the applications, you need to pay attention on the several aspects mentioned in the Article 62 in MiCA, such as governance arrangements, capital requirements, IML requirements, ICT-related risks, etc., etc. So before the MiCA, we had the situation when we had different regulations within the member states of the European Union. After the MiCA regulation, we should have the same framework, the same principles, and the same approach within the whole European Union, which will help the market participants to adapt to the regulation easily. How to prepare? First of all, start with the risk assessment. How compliant is your company with the MiCA? Create the roadmap. Start to prepare, draft the policies, review the policies, start your communication with the regulator as soon as possible. If the regulator is providing the opportunity to do the pre-assessment of the project, go for this. Of course, invest in the training of your team and employee, review the aspects related with the governance arrangements, and start preparation as soon as possible, as I said. Let's talk about the DORA. DORA is a regulation which is applicable to the different financial institutions. More than 22 financial institutions need to comply with the DORA. It is coming into the force 17th of January 2025. The idea of the DORA is to ensure the digital resilience for the financial institutions within the European Union, and it's creating the obligation to do the reporting to the competent authorities and to have the register of information which should be provided to the authorities. You can have a look on the pillars of the DORA. So here are the topics that should be addressed during the preparation. Here is the structure of the register of information. They are all templates are available in RTs provided by the EBA and ESMA. So you can have a look. They are very easily accessible. Reporting requirements, two reporting requirements. One is related with the major ICT related incidents, and also the voluntary basis cybersecurity threats should be reported. How to prepare? Start with the risk assessment. Review your third-party ICT service providers. Ensure the cybersecurity training within the company. Review your policies. And start preparation in advance, the same as with the MiCA. There is some additional regulations which will be applicable for the virtual asset service providers within the next year as well. So you can have a look on them. They are all important, but you need to always think about regulatory challenges and upcoming regulatory changes as an opportunity to ensure your company business activity and bring it to the next level. Thank you so much for your attention. My pleasure.